पहला WA 839/2026.
Not as if the equation that the commissioner gave. So many councils are crowding one.
What affidavit?
Last occasion, minor.
Any penalty you have demanded or anything?
That 10% has been deducted with the consent of the petitioner. My lord, kindly see the annexure.
Just give it to him.
Yes, sir.
Take an instruction.
No, I have taken instruction.
Yes, what?
My lord, can see the annexure.
Yes. I am looking at an annexure, page 5.
That is not legible. This was issued on 27.
So after 10%, whatever the remaining you just
So 90% has already been released. And that we have stated in paragraph 4.
I know 10% is not never agreed. This is
Then it is a disputed one. It's a disputed one. Then you go for another avenue. My own judgments are staying at your place.
This is not a disputed fact. The reason
Yes, that is disputed, then it can. If it is
Reduction is submitted application for waiver of the penalty. That is under active consideration by the tendering authority.
My lords, let me just this affidavit actually overreaches what the email and the subsequent communication states.
it becomes a disputed question of fact, then we'll have to prove it by way of an evidence.
No, my lords, there is all of this document that they are submitting was already in the writ compilation that I had submitted.
No, whatever, then it raises a dispute, and the dispute cannot be resolved or adjudicating in a writ proceeding.
My lords,
My own judgment of this court is stating at my face.
Allow me 2 minutes of time, my lords. Let me place on record.
Where is my judgment?
Raps and Infotech is
Whatever. Relying on two judgment of the Supreme Court.
ABL Enterprises.
ABL was a different, on a different note. I'm talking about this HON'BLE judgment.
Whatever Sugarmill and Sugarmill.
And the Pune Hinda judgment of the Supreme Court.
My lords.
Pune Hinda says, it says,
Paragraph 14.
In this letter that they had reduced, it's a letter that I have issued to them subsequent to a meeting. Before that, they had admitted the amount is.
Sir, subsequently, if they have raised a dispute and they are relying on a particular document that when they say that you have consented for it, whether it is a consent or not a consent cannot be decided in this.
Just let me explain the scenario. Just give me allow.
You can argue whatever.
My lords, this annexure, it is there in the annexure 8. There was a meeting that was held on 26th of February 2026. This year. In that meeting, what OMC told us, our representatives, that they are withholding 10%. So that is what is agreed, that they are withholding 10%. It is not our consent that has been agreed. Let me, my lords, can I draw your attention to page number 105, annexure 8 of our of the this thing. If you read, it was agreed that only 10% of the total contract value is being withheld. I never consented to the fact that this amount should be withheld. I said I agree to the fact that it is being withheld by them. It is a quantification of that amount.
Yes.
And subsequently, subject to providing a letter confirming the reasons for the delay, this thing, once the letter is received and reviewed, the withhold amount will be released. The timeline for review is currently unknown. That's a minute. Now, subsequently, the letter that has been issued is on page number 107, my lord. Kindly turn to page number 107. My lord, read the first line. Dear sir, this is a letter issued. read, my lord? Read, my lord? This is a letter issued on 5th of March 2026. It is issued by Geotech Infratech.
Letter of completion dated.
Yeah, it's not a completion letter, my lord. It is a letter following our meeting at your offices in Odisha on 26 February 2026, which is the email they're talking about. We write to formally request the immediate release of 10% of contract value currently withheld by OMC and the final settlement of our account. It never admits that we have agreed to this. And secondly, my lord, see, come to para number 1, contractual timelines. The original NIT referenced a 12-month schedule, but the letter of award expressly contained an extension, which they have acknowledged, of 18 months. There are 2 documents themselves they have issued, which has said the contract timing is 18 months. And they have never disputed this letter. After this letter, they have never responded. My lords, that is so.
Anything more?
My lords, let me trace the judgment of ABL.
Yes, ABL is a different one.
My lord, let me just quickly read it for you.
This is in relation to the Export Credit Guaranteed Corporation obligations. While making an export to Banda Karega.
In this matter, I challenge the tender rejection as well as the procedure that has been adopted by the tendering committee even before the finalization of the tender while my grievance was still pending with the authority. What? I'm challenging my tender technical bid rejection as well as the finalization of the tender during prior to the finalization. I had given a grievance before the tendering committee with regard to my technical bid rejection and with regard to the approval of the technical bid of other bidder who have been qualified, pointing out the discrepancy. And even though while the grievance was pending, they have gone and finalized the tender and awarded the work.
For the other side.
The state and for the aviator.
In whose favor the tender is finalized?
Yes, finalized. Yes.
Now let's kind of hand over the instructions, my lords.
Once they have raised and
They have been
adjudicated upon.
yes, my lords. On 1/7,
We have not provided anything.
C was disqualified as per clause number.
Was not digitally signed.
Yes, my lords. Clause number 4 at page number 27.
Then he also raised an person that somebody who has also not signed on this.
No,
There are 2 preconditions to that. Milots may have page 27 of the writ petition.
it's in the
Oh, you have said that who have also not digitally signed.
Yes.
They have already.
yes, my lords. On same grounds, whoever had not given digital signature, we had rejected their bids, my lords. Regarding the representation, my lords, last portion, last paragraph.
Oh, this was also communicated.
Yes, my lord. The document is also annexed to it.
When he has filed a writ.
Milots, at page 197, my representation. File the writ petition, Milots.
13/7, my lord.
28th of July.
Yes. particular melons, that disposal of my representation has not been provided to me.
Your client is sponsor.
Because I have filed it on 13/7 melons, that copy has not been.
You have writing on 88/7.
Because it was filed on 13/7, it is registered that defects were cured and registered on 28/7.
Even on 37, we get it, then also.
Because I have not been provided with a copy of the disposal of my representation order, Milords.
Yes,
Because let it be served, Milords. Your Lordship will direct to Milords.
we are discussing and then we will.
Milords, may I pass it over, Milords? I'll take the necessary instructions, Milords.
Well, also the subsequent representation which you have filed.
Is the solitary ground on which the decision of the tendering authority to reject
Lordship, here only the date of registration I have get. But in this case, Lordship, date of registration, Lordship, date of registration. But what I humbly submit, Lordship, in this case, I want to advance my argument, Lordship. Lordship, one from that line also, Lordship. That case, Lordship, can I remember this 5 years back, Lordship, first agreement. For what? No, Lordship,
was not raised.
registration. Yes. But now, Lordship, I want to argue, Lordship, because there are 3 agreements, Lordship.
You can't argue before the pleading.
No, and no, Lordship, within pleading, Lordship. Within pleading, I know. But
You relied upon a document which does not appear to have been registered. Now they have come up with document which shows that that was registered.
no, that is not my case, Lordship. Lordship, clarity of the document, Lordship, directed for date of registration, that is there, Lordship. That is there, Lordship.
Last page. Last.
Yeah, but there is also.
Not the back side. At the back.
I have a copy of the
1904.
No. I'll give us a copy. Yes, ma'am.
1904.
From 1904 to 5 years is a 18/4, 2026.
But Lordship, my argument would be, Lordship, I want to develop my argument in this manner, Lordship. Can you grant me some time? I want to develop my argument, Lordship. But here, Lordship is disposing all the writ application, Lordship, directing the state government to exercise the power under Rule 264, Lordship. Lordship, can you leave 1 minute, Lordship? Lordship, I will work on this particular point, Lordship. But Lordship, here, Lordship, they have considered my case because due to their lapses, the agreement could not be executed. Now they come up with an Annexure 5, Lordship. Lordship, kindly see.
It was executed in 2021.
No, Annexure 5, Lordship. Annexure 5, Lordship, kindly see. Annexure 5. Annexure 5, the same mining officer, the same authority, knowing value, Lordship, page, Lordship, 66.
Another spell.
Lordship, no, the same spell, Lordship, because that was for 1 year. That agreement was for 1 year. Though Lordship computed the period for 5 years, but the peculiarity of that agreement, Lordship, that was executed for 1 year only. That's why they come up with second agreement, and now they come up with third agreement. The intervening period, Lordship, they have adjusted, keeping in Lordship rule, mind the rule 64. And handed over the sale deed, Lordship, list deed, Lordship. Lordship, kindly come to page 3, Lordship, that is page 3.
Annexure 5.
No, Lordship, the document handed by. So, though the date of Lordship agreement is there, Lordship, but Lordship, kindly see. Column 3 says it is for 5 years. But column 4 says they have executed this list deed for 1 year only.
Column 5.
Column 4, Lordship.
Column 5.
5 is there, Lordship. Minimum guaranteed quantity per annum. They have given the figures, Lordship.
Up to what year?
Up to 5th year. Lordship, what they did, Lordship, but they executed the list deed for 1 year, Lordship. Then, Lordship, kindly come to second document. That is Annexure 3, page 42, Lordship. Again, the 42 they come out for another 1 year. Lordship, they have break up this 5 years into 3 agreements. Lordship, kindly see. Here, Lordship, also they come up with for 1 year. Page 45, Lordship, kindly see. Now, Lordship, they come up with the Annexure 5 because in the meantime, the department changed, Lordship. It is from revenue, it came to Lordship, the mines department, Lordship. So, for their realizing their mistake, Lordship, they come up with the Annexure 5. So, in exercising Rule 64, they have extended this period. They said 3 years, Lordship. They are giving me 5 years, not more than that, Lordship. And we are applying for 5 years. Now, the same officer can the Lordship, he can sit over as an affiliate authority, Lordship. So, Lordship, this Annexure 5 is by the same mining officer. And this, Lordship, I am challenging the document. I'm sorry. Annexure 8 by the same mining officer. Can he, Lordship? So, Lordship, there are number of ingredients, Lordship, to operate the sand quarry in question, Lordship. There must be a mining plan. If without a mining plan, I can operate, Lordship. There must be environment clearance. Without environment clearance, I can operate. There must be an agreement, Lordship. Without agreement, I can operate. Lordship, there are number of, Lordship, the factors. In absence of any one, Lordship, I can't operate. So these are the, Lordship, for this reason, because they provided me for 1 year, I operate for 1 year. And as per their Lordship instruction, I obtained an environment clearance. Now they have passed this knowing fully well because of their lack of the department change. For that reason, they have adjusted. Lordship, just like Preston Man's case. These authorities have considered, the government has considered, knowing fully well, and they have come up with a fresh agreement. So this fresh agreement, Lordship, is a for up to, Lordship, that page, Lordship, kindly see page 68, Lordship, kindly see. Page 68, that is up to 31st August 2027. So, Lordship, this is in consonance with the rules. It is never contrary to the DS the rules, Lordship. Your Lordship has given number of direction to consider this case, and the government has taken conscious decision by extending the lease period by way of executing fresh lease deed. So they have done it here, Lordship.
Is anything more?
No, Lordship. So that's why, Lordship, can you grant me some breathing time, Lordship? I want to come up with a, Lordship, healthy argument, Lordship, so that I can convince the Lordship.
What more?
No, Lordship, I can come because Lordship.
Your argument one can do.
So, Lordship, to convince the Lordship, I want to.
What is your argument you have done?
No, Lordship, still it is doubt in my mind. I will come with your Lordship better preparation. I'll come with better because with a good case, Lordship. I don't want to lose this case, Lordship. I want to convince the Lordship.
What?
I want to convince the Lordship. Can you grant me some
No,
time?
earlier sentence, what is it?
Lordship, because Lordship, that's kind of only after Lordship, so that I come up with it, Lordship, with a convincing argument, Lordship.
We will consider this.
No, Lordship, let me, Lordship. No, Lordship, kindly grant me at least next week, Lordship.
No.
At least come next week, Lordship, so that I can advance a better argument, Lordship, to convince the Lordship. Because
Yeah, but what's the best argument?
no, Lordship,
Better means.
still perhaps doubt.
Superlative.
I have not cleared out doubts.
No,
Honorable Court,
there's
Lordship.
no doubt.
Lordship,
Have we said anything on that? We simply heard you and then wanted to dictate the order.
No, Lordship.
No.
Let it be next week, Lordship. I will convince you.
No.
Because it is largely in consonance with rules, Lordship.
One day. No further argument.
Item number 5.
May please.
My friend is asking for 2 o'clock. 2 o'clock.
For whom?
He's appearing on behalf of the railways.
For whom? Railways.
It's come up for the first time. o'clock, ma'am.
Let him come at the leisure time at 3:30.
3:30. Because I'm ready, Manoj. I can place my case. 3:30.
3:30.
We clearly list item number 1.
Obliged.
Let me tell you what is this case. So this is regarding grant of exclusive privilege of liquor. But there are three types of liquors basically. One is IMFL. And let me tell you
that these schemes which have been
what I'm saying is,
no,
all that I'm saying is this. Your Lordship is right. What I'm saying is, you now have a scheme where every grant is for 5 years. So country should also be 5 years. And wherever there is country liquor, now, suppose somebody's license is cancelled, he gets also for 5 years.
So your green intake, but the problem is that
all the time
shop
yes,
is kept outside the purview of that particular.
I'm ever so grateful to you. I'm ever so grateful. That's all.
What is your case?
That's all only my case because let it be for 5 years.
There is the judgment of Naveen Kumar Singh.
Lord, although we have extensively referred to Naveen Kumar Singh, this is the policy decision of the last of this thing. This really may not be of great help to me, except that in the counter affidavit, the state has said that we will follow the principle of auction. Lottery. Lord, all that I'm saying is, you have a lottery and a time for IMFL. You have a lottery and time for country liquor outstill. For country liquor retail, please have some period for country liquor outstill. Don't make it open-ended for 10 years, 15 years, 20 years like that. That's all I'm asking. So let my learned friends respond to that and the Lordship may then decide.
Synopsis page C.
If your Lordship sees the synopsis, kindly see page synopsis, not page C.
What is the difference?
Lord, what happens
What
is,
is the difference?
I'll tell you Lordship. Lordship may see page C of my synopsis, just for half a second. There is somebody, I've given 5 examples. Somebody is continuing from 2001, 2002. Somebody is continuing from 2005, 6, 5, 6, 7, 8, 17, 18. So they are carrying on for monopoly for long number of years. And today, if an outstill shop is cancelled or
What
surrendered,
is this outstill shop?
outstill is where they produce from Mohua.
So this is a manufacturing.
Yes. So today, for a manufacturer, if I am a manufacturer, he is a manufacturer and retailer both. If I am a manufacturer and my license is cancelled or I surrender, the next man doesn't get it for eternity. He gets it only for 5 years and then there's auction. Your Lordship will straight away see that document. Kindly see page 2.
Outstill is already outside the purview. Then the
Yeah.
question of 5 years is not arrived.
No. Today, for example, kindly see page 264, annexure 9 for a second. My Lord Sir, 264.
Yes.
This is sale notice inviting applicants for settlement of exclusive privilege. Kindly see the date, 25/6/26 of outstill country liquor shop. My Lords have it. Now kindly see, my Lord, for the new ones, they get it for how many years? Kindly see page 265, serial number Roman 8. The exclusive privilege once done shall
in the year of grant.
all that I'm saying is, if you are now giving for fresh people for 5 years, people who are holding for 20 years, 25 years, 30 years, make it for 5 years and put them to lottery. That's all I'm asking. That is for people on my left and right.
And up to pay inspection.
Why
Questioning
policy? Why not the uniformity? How much time more?
2 weeks, you know, significantly to the package. Come back.
I know, yes.
My Lords, and I say in lighter note,
application and license fee with regard to Orissa Excise Act. My lord, I've heard it extensively. My difficulty is that, my lord, I'm using molasses as the raw material for manufacturing of gurkha, my lord.
Consider that. Consider.
Can it be taken up next week at least?
Yes,
Press admission.
We'll see to it. Don't,
Press admission.
we'll see to it.
Asking for press admission.
Let us.
Item number 2.
46 minutes concerns the Mahaprabhu Jagannath movie. The Honorable Apex Court has meanwhile passed orders, 2 orders. After that, nothing remains. Because of the pendency of this application, we are not able to get any slot for movie releasing. Sir, any fixed for either tomorrow.
Well, it's next week.
I think maybe not.
Okay, general will be here.
There is an item number 1 because we are not able to release the movie because of this pendency.
Yes, we'll see to the orders.
All the orders.
Whatever the Supreme Court has passed, we'll see to it. Yes.
Item number 2.
Item 2, my lord, I personally urgent movement. Next week.
2 weeks.
Item number 3.
Item number 3, this is regarding surrender of liquor shop license. My lord, petitioner has applied for surrender of liquor shop license. His application was rejected. The improvement.
Why you reject?
Shop belongs has been freshly resettled matters under the new lottery system, so he is no longer a licensee under the regime. It has been settled in favor of a new.
So I implied surrender. What remained then?
Yes.
Item number 4.
I need a couple of weeks to file my rejoinder. They've served me a copy of the counter only last week.
My lord, immediately, do you want to argue? He said that it will be requested to fix it to last week of September.
Why, sir? I do not want. You have filed a counter, then why you wanted such a longer time to come?
I need only 2 weeks to rejoin.
After 2 weeks.
Time to file rejoinder is extended by 2 weeks from there. This is the matter.
We heard this matter on 23rd and the lawsuit directed to file an affidavit. This is a matter wherein none of the petitioner submitted his application for lawsuit. Recall that application because of some mistake, bona fide.
The for non-submission of the no due certificate.
Well, we could not be able to participate because with that bona fide belief that since he was not having or running any shops during the time of.
Why you go?
It was not revealed that he was creating under license state. That about the due certificate was.
Have you filed your counter?
In similar
Counter file instruction I have already received, my lord.
No, there was a direction for counter.
for affidavit, my lord. And the
No
petition-
direction for counter or not, only for the.
Lordship may kindly.
Yes.
Affidavit filed, my lord, on 27th. In similar cases also that.
No, you were granted a liberty to file additional evidence.
That filed. On
In that,
27, my lord, they have filed. Serve the copy.
my lord,
The
that
lottery
affidavit that
filed
relates the case where if a lottery is held, that person made a dependent to commissioner to consider the case.
Same.
Because lottery was not held, but after lottery he made the reprint.
No, on the same.
And now we cannot
Only,
consider
my
that.
lord, here the difficulty is that on 12th the lottery was fixed and only on the same date I made an application. So unfortunately my application could not be considered. So
Same
since
day
I could not
that lottery
participate,
can be considered.
subsequently
That is not that-
since I could not participate, so I just
File your
on
affidavit.
the-
State, the state is directed to file counter affidavit.
Adjournment.
2 weeks.
Item number 7.
Yes.
Hand over the disclosure of the application of the petition minutes.
What?
Order that has been passed by the collective society and object order minutes.
Yes. Have you taken a decision? Under what authority you have?
The only ground or on the.
Somebody comes and claim a right in respect of a property and then you will adjudicate.
The point here is that the license is granted at X place. He is not operating at that X place, members. That is the finding of the collector.
What?
Here in this case, the license was granted to the petitioner minors at 3 plots minors. After the inquiry report, it was found out that he was not operating at that place.
The declared place.
Yes, ma'am. It's at the declared place as per the license. Hence,
The entire hotel is constructed on 3 plots after amalgamation of all the plots.
the different plot numbers are mentioned.
I am asking you, sir, madam, try to understand. There are 3 plots. All the 3 plots were amalgamated, or on the above 3 plots, the construction has come and they are operating within their hotel. So how can you demarcate that it is in one plot, it is not in another plot?
Refer to my lords, sir.
Let me understand the law. I do not know. Let me find out.
My lords,
Is it a case of all the 3 plots being amalgamated and the one structure has come on 3 plots?
And lordship, the reasoning laws are dispute. Yes.
the last page of that order, my lords,
Yes.
let me read. Considering the fact of the report of Tehsildar Kontagji and going through the available document, it is observed that as per the provision, previous demarcation conducted by Tehsildar Kontagji, Hotel Midtown building and IMFL on shop is not situated over plot number 858/1313, 859, 1315 and 860 or 1313 under holding number so and so.
Then where it is situated?
Next.
Page number 23, my lords.
Then where it is situated?
Page number 23 of the writ petition, my lords. It is situated over
No, Rule 55 says a license is a sale only in the place specified.
Yes, madam.
Since there is a dispute on the ownership.
Despite lordship, two observations, two directions. This is the finding of this officer.
Let me understand, because then what the Tehsildar said, that this entire hotel is situated where?
Then it's there. So the Tehsildar's report, madam. And for the Tehsildar's report, it mentioned there is existing over 858, 859, 816 million.
And these two, all these big plots, and the butterflies, they are differently located.
Yes, madam.
858,
one-
859, 860, and 858 by 1313. And 1313
That's
are
what the-
two different places altogether.
No, what the Tehsildar in the report, if I may, which I have handed over there, saying that all the properties are in possession of the petitioner, madam. But where the license has been granted and where the shop is running are two different places.
That plot is a consolidated plot of different.
And it's also because,
Consolidated plot of.
because madam, also in the previous litigation, madam, wherein the excise commissioner had passed an order of demarcation. That demarcation was also stated by the petitioner in a writ petition, which is also pending here, madam. In a previous round of litigation, there are two other writ petitions which are pending, madam.
Yes, sorry.
Lordship, I have your question.
It is what it is.
Lordship, can you see the first?
Please, can you give me a sanction, but
Lordship, page number 23 is the license. Sorry.
wait for some more judges. Let us have a session. You are giving me a ROR. I am asking.
Lordship,
for
building plan.
Building plan.
Lordship,
Without the plan being sanctioned by the municipality or
Let's-
corporation, you cannot make a
Let's-
system.
It's coming under the NAC lordship, not municipality. NAC lordship, but lordship, license their lordship.
No,
Building-
I just want to
Building.
know the sanctioned building class.
Just now lordship, I
You
know.
have constructed a hotel.
Lordship.
So there must be a class.
Yes,
sanctioned by
there's a
the-
plan, lordship, there's approved plan is there,
You
lordship.
should not make a construction.
Lordship, that plan, for the time being, we don't have that, lordship. Tomorrow.
Do you have any order of amalgamation?
That is there.
No, that is not an order of amalgamation. If
Yeah,
there are
this is
three
true.
different plots,
Then, yeah,
if you want to amalgamate the plot, there must be some issue.
But they have plan, but
First deed of amalgamation. Because all the three plots are owned by you.
But their lordship, they are granting license in 2002 lordship, they are granting license for the same plot, same building.
Now, are you not realizing where we are heading?
Lordship, that's the lordship there.
If they have taken a particular view, let us understand that how they, what is their knowledge about these kind of a things. Let us understand.
But here lordship, they taken a view that the dispute is there.
No, sir. There are two things they are saying. Very interesting. That's why I'm asking you to give.
Building plan lordship.
You are talking about a carved out plot.
Right.
They are saying that it is not on the carved out plot, but it is on a larger plot. Interesting. This is not on 868 by 1315, but 868. 868 is a larger plot. From there it is carved out. So there is a apparent anomaly. They do not understand what is the meaning of, in other state we call it a butter plot. Here I do not know what word then butterfly, but it is a larger plot. From this a portion has been carved out. And when we say it is on a larger plot, then it includes that
hand over the previous demarcation where it was done in 2023.
one room is in 860, another room is in 858.
These
When the entire building is on the three plots.
what they are saying in that earlier report also is that those plot numbers where petitioner's hotel is present, my lords, it's recorded in some other person's name, my lords.
Show us that 868, 869 is recorded in others' name. Show. Let us see. Where is the ROR?
In fact, produce the ROR thing, my lords. ROR is not, this is the report. This one is.
Which one is the B plot?
Aside from the shaded portion, my lords.
Shaded portion, no?
Yes, my lords. As far as I can see, the B is written there only, my lords.
860 and a corner of the 860, that is a butter plot which is situated.
Yes.
B is the portion.
It's that knowledge, my lords, and I don't have my lords.
No,
Because I was going through the report only. my
We are
lords.
calling, who is the revenue inspector? Let him come now. That's all. Just
Let
let him
let it-
understand.
My lords, everything let me file an affidavit to effect because earlier writ petition of the same stand has been taken, my lords. In all the two writ petitions which are pending, my lords, in those also, this is the same stand which the state has taken in all those matters, my lords. I'll file an affidavit disclosing all the records, my lords. But I'll file an affidavit.
Go.
Once I'll file
When
everything.
you wanted something to be done, let us, don't go, let them come. I'm just calling them to come and justify. And let them come. You also give me that particular site building plan.
And page
Let us
26.
see on the next day.
Plus, page 26 also, their own report also there. Page 26. Page 26, Lordship.
Yes.
Also, Lordship direction, the same authority is given the report, Lordship, kindly come to page 26, annexure 4.
Which portion?
Lordship, come from page 27. On perusal, Lordship, last paragraph, it starts from the 3 paragraphs suffice, Lordship. They get in the entire picture, their own, Lordship. May I read, Lordship?
Yes.
On perusal of the document submitted by Sri Girish Chabra, the licensed hotel Midtown HON'BLE on shop, Kantabaji is revealed that by virtue of the registered gift deed by document number 55712, date of execution deed dated 10/5/2, he has acquired the gift property donor Jaswant Singh Saluja, aged about 45 years, son of late Indra Singh Saluja, Kantabaji, Doni Girish Chabra, aged about such and such lordship, just a lordship. By plot number 858 Kisam Khetta Adi, acre number such and such, acre 0. Such and such, marked as A out of total area acre 0.150 decimal, and plot number 859 Kisam Bhala Mamuli of an area of acre 0.07 decimal, marked as A out of total area of acre 0.13 decimal, and the total area is an area acre 0.08 decimal. Then on perusal of the document submitted by Girish Chabra, the license of Hotel Town HAML on Kantamaji further revealed that by virtue of registered gift deed donor Amarjit Singh Saluja, age about 40 years, son of late Indra Singh Saluja,
On perusal is also previous one, this one.
Lordship.
Current page 28.
post page 28, Lordship. Page 9, Lordship. On perusal, there is copy, Lordship.
On
ROR
submitted. There are copy of the ROR submitted by.
Girish Chabra. License for Hotel Midtown HON'BLE on shop, Kantamaji, is revealed that he is the recorded tenant of the land by Khata number 227/325, Mauja Kantavanji Co. of plot number 589/1315, Kisam Gharabari, area of acre 0.07 decimal, plot number 858/1314, Kisam Gharabari, area of acre 0.01 decimal, and plot number 860/1313, Kisam Gharabari, area acre 0.022 decimal, total area of acre 0.03 decimal, consisting of above 3 numbers of plots. From the Xerox copy of the plan submitted by the Girish Chabra, it is transferred that as per the plan approved by the executive officer, notified acre area council Kantavanji, dated 26/2, Girish Chabra has constructed the ground floor of Hotel Midtown over an acre of 0.07 decimal and has
area
7 decimal and has constructed second floor and subsequent floors as per the plan approved by the junior engineer NAC Kantavanji, dated 14/9/7, and countersigned by executive officer NAC Kantavanji, dated 14/9/7.
That is on what plot?
It's page number 23.
That's I have annexed the license, Lordship.
860 by 1313. Chapter number 227 of.
Page 23.
Yes, Lordship.
Page 23, that is.
Page 25, Lordship, last column, Lordship, page 25. 6. Over 3 plots, Lordship. Page 25, Lordship. Page 25.
No, 25 is the revenue inspector.
License is 23.
We are not on that. License.
License, Lordship,
License
is
is
23.
23.
23,
That
Lordship.
is only one plot.
Lordship.
Over plot number 860 by 13.
1313, that's the number, Lordship. Lordship.
Sure.
Lordship. In criminal proceeding, Lordship, subsequently decided, page 53, the same assertion there, Lordship, where page 53 in criminal case, where we have been acquitted, Lordship, on the same charge, Lordship, on page 53, and code below has a Lordship, observe the entire situation of this IML answer, Lordship.
That
Page
was
53,
both the parties, my lord.
Offense was
That-
what?
No, that
448.
was between both parties, my lord.
448 and
This is not a
For
dispute
24,
between
40.
excise and the.
that has been acquitted.
That is the state versus jail.
No, it was not. My lord, the complaint was by
Criminal
the.
proceeding,
But I mean,
who prosecutes the case,
no, my lord, I mean to say the.
criminal case is the state.
No, my lord, I mean to say not excise department, my lord. I
Oh,
mean.
excise department is outside the state department. They are absolutely independent
that was-
department. They are not the
The
instrument.
informant was alleging encroachment by the petitioner, my lord. That was the allegation in that. Yes, my lord.
So,
It was found that they are not unprofessional.
But we have to see with the license, what's, I could gather, my lord, so we have to see from the license.
And no enforcement has been made by the.
yes, that is. Yes,
Page 40 and page 53. Page 40 is her own admission that I am there, Lordship, repeat there. Page 40, Lordship. Page 40 is her deposition. Serial number 11, Lordship. It is fact that my husband had gifted acre 0.01 decibel of the said plot, acre 0 decibel to the accused. And Lordship, page 53.
Let us see.
Item number 8.
Get into, go to the seniors, they will tell you how we land.
Yes, Mr.
Or being distributed, recorded. They do not know what are the CS cadastral survey, the revised survey here in Odisha, I do not know whether the CS RS that was done.
Survey settlement ratio that is.
Survey settlement. We used to call it a Gujarat.
Available net.
Gujarat.
Volek ROR will be collected. Volek portal of state government, the ROR will can be collected, and Noksha can be also collected.
They were setting up of the tent, the village, and asking the farmer.
Settlement, let's will say.
They will not know.
ROR Naksha, with the reference to it can be ascertained.
No.
And the survey
Map.
map.
So there is a conflict in the very portion of land where the construction has been done.
And the existing building where the shop is running, that requires demarcation also.
No, not required, sir. The difficulty is, that's why I'm saying, if 3 plots have been amalgamated and the construction has come over all the 3 plots, then it loses an independent identity, except for the purpose of revenue, but it will be regarded as any portion which can be used. Yes.
Item 8, though I have received the instruction, there are some factual errors. So that is why if lordship allows me till next week so that I can.
He wanted a surrender.
I want to surrender my license.
His surrender
That has
application
been
was
rejected.
rejected. Your
All the
lordship.
persons who wanted to surrender comes to him.
No, my lord, as far as the MGQ is concerned, it is still due. He has not cleared that. That is what.
My lord, may kindly see page
instruction is.
14.
But there are some
My
factual
lord, may
errors.
kindly see page 14.
1-4.
1-4. So this is the impugned order. Second paragraph. What reasons, my lord, what reasons they have assigned? Whereas due to non-deposit of required dues, the license of the shop could not be extended. Due to non-extension, the license of the shop in the name of applicant is not in force. Without having a valid license, the claim of the applicant for surrender of the license may not be
So it
considered.
is an implied.
So, my lord, they are forcing me for an extension. They cannot force me. My license is valid. My lord, may kindly see page 28. All dues. My lord, may kindly see page 65. For a moment, page 65. Page 65. Lordship previous order. Para 12. It leads. Para 12. It leads to an inescapable conclusion that the absence of excise policy for the year 25-26, when the excise policy for the year 24-25 is extended, the order of rejection is not sustainable, valid, and bad in law. In the interregnum, the petitioner has already lifted the shortfall of the MGQ and has also paid all the requisite fees and all statutory charges which have been considered by the authorities in this regard, and therefore we do not find.
Then para 13, your lordship, may kindly. Para 13.
Lordship has
Since
already.
the order impugned is based on extraneous and or.
The impugned order of they have clarified that I have paid all.
Hereby quashed and set aside, the competent authority, Collector Bhadrak, is directed to reconsider the said application afresh. And it goes without saying that he will also take into account the lifting of the shortfall of the MGQ and payment of all statutory.
That means that one corroborates that the shortfall MGQs have been lifted and the everything.
Yes,
paid.
that is also.
So say that you will take into account that it has already been lifted and paid. This is what a paragraph 13 comes.
For this next week so that I can.
Next week.
Till next week. Next week, because the instructions they have
the all. Sorry, we can't make the problem. Let him take a stand. We'll see to it.
Item 9.
the instruction, there are some factual errors, so that is right.
Last appraisal also directed for taking instruction. Remember, I got the lottery in the year 2017, my lord, for opening of IMFL. But till today,
If I put all these instructions before my lord should impose a heavy exemplary cost on the petitioners. Twice he traveled to this court.
Yes,
Yes, your lordship, my kindness.
9932 and 20730.
Yes.
He has disclosed this.
He never participated. He has disclosed not the entire fact. He has only said that my writ petitions were disposed of, but no action has been taken by the state. Although his applications pursuant to the first writ petition was rejected by the excise commissioner, then pursuant to the second writ petition rejected by the collector. So I have flag marked for my lord's convenience. So lordship may kindly see the orders at page 100. Page 100, this is the first order passed by this honorable court directing the excise commissioner to consider. Then the second order by this honorable court as at page 101 directing the collector to consider. Then your lordship may kindly see page 103. This is the order passed by the excise commissioner on 16/7/2019, and this was communicated to the petitioner. The lordship will find at page 105 by virtue of memo 16/7/2019. Then page 106, this is the order passed by the collector in presence of the advocate who was appearing for the petitioner before the collector. Petitioner has deliberately suppressed all these facts, my lord, in the writ petition. And twice the shop was put to lottery. He never participated in the lottery, and he wants the shop to be given to him. And this is how he has traveled for the third time to this honorable.
these things.
Short affidavit by next Tuesday. Bring that to the city.
Okay. No, I will permitted to withdraw. my lord.
Anything under the heading 4.
Item 10.
Thank you. In this matter, last occasion I have taken leave to file amendment application and I am filing because after filing of the writ petition, they have issued document number 4 issued licenses. So to brought to that
They have
record
issued a license.
after filing of the writ petition. They have issued a license and after filing of the writ petition, they have filed another license stipulating minimum guaranteed excise revenue. Because now from this year, they have introduced minimum guaranteed quantity against
You wanted to amend and check
yes, Lordship.
the player as well as the available
Lordship.
in view of the subsequent.
Yes, Lordship.
This amendment I just received during pendency application, he has made a representation to secretary to consider on the point of discrimination.
That
was
also
similar to certain CA local unity they have been discriminated and fixes not revenue. And therefore that is pending on 24/7 again. I will take instruction that what happened.
But amendment has to be allowed. Yes, necessary. This is an application for amendment of the writ petition.
No, in this case, 11 below, We taken up next week because instructions are not some. Next week.
Surrender.
No, my lord,
No,
this is not
this is
it. Yes, they have permitted liquor shop other than sanctioned
Yes,
location.
let it come next week.
Item 12.
May I trigger? But the appellant is the wife of the respondent, ma'am. That is in the
Challenging the thinking for the what?
my lord.
Under section 13(1).
My lord.
Cruelty or desertion, what?
Cruelty and desertion both, ma'am.
What? Proved by the husband.
By the wife.
Then why you are challenging? Why you are coming as an applicant?
My lord.
Proved by the husband against
Yes,
you.
yes, ma'am. Sorry.
Proved by the wife. I was surprised.
Proved by the husband that
Then why appeal? If you have proved your cruelty, then why you are coming in appeal? Huh? This where is this for the other side?
We are for the other side.
What have you done? This is a scenario of how then everything was done, everything is completed. After such a long time, can you reopen the issue in this way?
But you listed for first time. You listed for first time. They have asked me to take time in this regard. But
Who
I
has
did
asked you to take time?
say this. It is the DRI Mumbai. DRI Mumbai is there is a commissioner of customs prevention Bhubaneswar. It is dealt with by the DRI Mumbai. So they were directed revenue intelligence Mumbai Zonal Office. They will apprise us in this regard. So that took time, 3 weeks time for this. This should be.
What are you talking about? Because
That's the time.
it was a tripartite agreement. And on the basis of the tripartite agreement, they reported.
Only this much of instruction I received.
Month of May 2013.
This much of instruction I received. Because the first time it is listed, it will not be admitted or no.
The first time or the second time or the last time?
We sought for instruction after receiving the copy immediately.
No 4 weeks time. Sorry, we can't grant. If you have all the documents after 13 years or 12 years, then you should not take a plea of.
Let's make
4
it
weeks
after
time.
2 weeks.
Sorry.
Let's make it after 2 weeks.
Next week, you have to take instruction. Let them take the instruction in the next week. On the prayer of the DLC,
On this identical import,
regarding
What are you doing? Valuable government land have been enclosed. And you are not taking any steps.
Some steps have been taken,
What steps have been taken? Under the OPLE Act or under the OPPE Act?
Yes,
Page 127, lot frequency is applied. Page
they are-
127 is the photograph. Waist height water log.
What?
Waist height water logging during the rainy season in Raulkela. Taxi stand, lordship में 127. I've given a copy of the.
Because of the encroachment.
Yes, encroachment over the government lands, drains, everything. And there has been a standing order by the Annex of 5 to make it a time-bound program and report to the collector. And your lordship has dealt with this matter of encroachment of government and issued certain directions, the general directions. And the Supreme Court has given a direction while dealing with a public interest litigation, saying that actions must be taken against the hearing officials in delaying the this eviction process now. And that is
Annexure 1 Miller to the writ petition Miller. That is Miller the series of steps that we have taken.
That's so collected.
Sir, what are you talking about?
Annexure 1 Miller.
Give a name, we are including a person who has created an obstacle. We are adding him a party. You have said only the designation, give the name. You have given a designation. Last page. Penultimate paragraph.
Last 2 lines. The second page Miller.
Yes, second page. The first paragraph, last 5 lines from the bottom of the paragraph.
That's
Give the name. What?
Lord, what he's trying to say, Miller, that
No, let him. He is
But
old enough. At least we must appreciate this particular officer. At least he has the courage to say so. Give the name. We will include a party. We will include him a party
Miller says,
or whatever.
in this rate petition, Miller, they have not given any site-specific details where Miller this encroachment is and all. They're making general allegations. So, Miller,
Sir,
what
you have perceived that what he wanted
they
to
have
say.
under Annexure 1, they have annexed a series of notices that the authorities have issued.
Sorry?
Eviction notices. So, in accordance to that Annexure 1, they have given this instruction. That out of those many eviction notices issued, some have approached various courts. And Miller, in some cases, steps they are taking, but they are facing other kind of problems. That is what he is trying to impress.
That we have collected certified copy of the eviction order. As a homework, the citizen before coming to this
Miller,
collected.
here, Miller, Raulkela is the urban area, Miller. So the municipality also, Miller, has to be noticed because they have also, Miller, they also have to take steps for corporation.
Trial will be done by the corporation or by the state.
Because in some areas it will be mostly Miller by the municipality, municipal corporation, because it's an urban area. Miller. But some areas, Miller, which are not part of the urban area, there the Tahsildar will do. So it's a Miller joint operation basically, Miller. But Miller's
under the OPLE Act or under these acts, who's the
Miller, in
Municipal
OPLE Act,
corporation.
Miller, is for the rural areas.
Commissioner.
Municipal commissioner will drive the eviction within the corporation area.
Yes, in the urban areas it is the commissioner, but in the rural areas under the OPLE Act
It's
the
not
Tahsil.
rural area, in fact, it's the heart of the town
Yes,
and adjacent to the railway area.
so that
Yeah,
will
it's
not be.
government area is there, some government area.
So for that will not be notice.
Have you transferred the government land to the municipality or municipal corporation? What? They talk about the government land, which is a
The big case is there.
Have you transferred?
Miller, government land will not, super Miller, if the land comes within the jurisdiction of the Miller urban area, Miller, then Miller.
No, but you are going to that.
You do not
OPP case
know.
has been initiated. OPP case has
Well,
been initiated. That will define which land,
Yes,
land
yes,
belongs to
Yes,
corporation or to the government.
Yes.
But under the Municipal Corporation Act, there is a provision to
Might
drive.
be, but who has initiated the proceeding? And additional proceeding has been taken.
Sir,
after
the-
that.
Apart from the fact that that is for the interest of the public, whether the government or we will do it, will joint effort of the government and corporation will do it, madam.
So, my lord, in this case, my lord, will give us some time, my lord, so that my lord, appropriate steps can be taken. They have taken some steps, but my lord, again, that is not enough. Has to be done, my lord.
No, when he has said that, tell me.
That line, my lord, my lord,
Give
he has written that.
The name we wanted to bring in.
The my lord, ignore that line. He has written that.
Maybe the intervention of local MLA with the public.
We are not saying so, we are all right.
That is.
What I'm asking.
My lord,
We'll take care of it, madam.
But you have to impede a party, whoever will there, how can you resist the authorities to discharge the duty there's already in the act?
What he has said
Or
is, my lord,
or
on that day,
statute.
yes, my lord, well, on that day he could not do it because there was public law and order situation, but he has, again, now, my lord, he has to do it again.
No, he says that now everybody is busy in the
I think,
expansion
yes.
of the Raurkela steel plant. So I
therefore-
can't provide you.
So therefore, my lord, the second time, my lord, they could not do it, but now, my lord, I will discuss with him, my lord, to let it come along. They cannot postpone it indefinitely, my lord. They'll have to do it, if not today, then tomorrow, my lord.
The instant repetition
the matter, my lords. My tender has been wrongly rejected by the railways upon a pure misinterpretation of the clauses on which I have relied.
What?
My lords, if the lordship kindly sees, the rejection, the impugned order is at running page 26, my lords. Annexure 1.
Non-responsive on the.
As non-responsive on account of non-compliance with clause 2.14.1.1 of the RFP. My lords, I'm taking your lordships to clause 2.14.1, but it is at running page 59. Lordship gets it. Yes.
Yes.
2.14.1.1. It is mandatory for all the bidders to have class 3 digital signature certificate DSC in the name of authorized signatory, stroke firm or organization, owner of the firm or organization from any of the licensed certifying agencies. Bidder can see the list of licensed CS from the link to participate in e-tendering. DSC should be in the name of the authorized signatory as authorized in Appendix 2 of this RFP or person executing, delegating such Appendix 3 in favor of authorized signatory. It should be in corporate capacity, that is in bidder capacity in case of consortium, stroke JV in the lead member capacity as applicable. The bidder shall admit documents in support of the DSC, class 3 DSC. In other cases, bid shall be considered non-responsive. Now, my lords,
You are a consort.
we are a consortium, my lords. We are the lead member, that is Shanti Engineering, and the second member is LLC, my lords, of Russia, my lords. So we had bid together, and I have been duly authorized by the other company, that is the Russian company, under Appendix 3 to be the lead member. Now, my lords, as per the bidding guidelines, if your lordship kindly turns to page Annexure 4, which starts at page 156, at page 160.
Yes.
My lords, step 2. These are the steps for giving my initial registration for online bidding, my lords. In the e-portal, my lords, I have to first get myself registered in the e-portal of the Indian Railways e-procurement system. My lords, step 2, click on the DSC of your firm to select the same and then click on select button. This will open the registration interface. Now, my lords, then it is important, it has been given, if your lordship kindly sees, that important is that I cannot change this DSC of the firm at once I register in the name of the firm, I cannot change it at all, my lords. Name of entity, important, the name of firm has been picked from digital signing certificate, and the same cannot be edited or changed if the name of the mention in DSC is incorrect. Please get the DSC updated. So I cannot change this DSC, my lords. So initially we registered with the DSC of the firm, my lords. That is Shanti Engineering. I have been authorized by the other member to by Appendix 3 to bid on behalf of the company. So, my lords, we registered in the e-portal under the DSC of the firm. This stands because in the name of the director, Rahul Junjunwala. Sorry, Rahul Didwania. Now, what happens, my lords?
I think one of the same.
Now, what happens, my lords? The company has 2 directors who have been authorized by the board of directors to delegate signature, delegate the power of attorney to any other person who will be participating in the tender process, and accordingly under Appendix 2, which provides for delegation of power under for signing a bid, my lords, one Saurabh Ghosh was, if your lordship kindly sees page 173, Annexure 5.
Yes.
If your lordship says, no, all men by these presents, yes,
Power
of attorney as per Appendix 2.
Special power attorney or specific power attorney? Only for the purpose of signing of the bid.
Of the bid for this project. No, all men by these, we Shanti Engineering Private Limited do hereby irrevocably constitute, nominate, appoint, and authorize Mr. Saurabh Ghosh, son of a. So this power of attorney is given. Who gives the power of attorney? Well, the company gives the power of attorney. They are the bidder in their corporate capacity. Now, this power of attorney has been given by Rishu Agarwal, who also has a DSC. Rishu Agarwal is also one of the authorized directors of the company, authorized by the company to delegate power. Now, accordingly, my lords, Mr. Saurabh Ghosh signs all the hard copies and they have been uploaded. Now, the railways also accept the same and doesn't point out any defect.
Here's page 191.
Page 191, it starts, my lords. We are at, if your lordship kindly sees, Annexure 9, page 191. Status of receipt of physical documents against T number is valid. Lordship, this is valid. Documents received, remarks. Then at 2:30, my lords, this is the status of our technical bid. Evaluation of technical bid. Page 230, your lordships will kindly see. Physical documents received, confirmation 1. Shanti Engineering Private Limited, Engineering Con Private Limited, Korba.
What? Which one? Serial number?
Serial number 1 and physical documents received at running page 230, your lordship.
Yes.
Physical documents received, confirmation 1. Shanti Engi Con Private Limited, Korba, valid documents received. Document status is valid documents received.
I am unable to get it.
Page 230, your lordship.
Yes, I am looking at page 230. This is the document.
Yes, sir. Physical documents received, confirmation.
Physical document
received, confirmation.
Oh, this is say the head.
I'm sorry.
Say that I am just looking at.
No, I'm really sorry.
Second main block.
Yes.
Then you are.
Serial number 1, Shanti Engineering Con Private Limited, Korba. Valid documents received.
Yes.
The documents are valid and
Page 35.
Your lordships may then kindly see page 235. The heading starts at page 232. If your lordship sees, after checklist, digital certificates used.
Page
232.
After checklist.
After checklist, your lordship sees there is another heading, digital certificates used. Yes, my lord. Then your lordships may kindly come to page 235. First column itself, Shanti Engineering Con, Rahul Didwania. And then they say, third column also, serial number of the digital signature is mentioned. Organization is Shanti Engineering Company Private Limited, Korba, street number such and such. No objection till that date, my lords. And my lords, I have to register myself in the name of the firm, as I have shown your lordships the guidelines. The firm, my lords, he is the director. Later on, one of the other directors, the company has authorized Mr. Saurabh Ghosh. It may be through another director, but ultimately, my lords, the clause is, my lords, they have misinterpreted the clause. Clause specifies the person. The person means the jurisdiction. If your lordship kindly sees the clause itself, first part is it is mandatory for all the bidders to have class 3 digital signature certificate, which I have. Second part is DHC should be in the name of the authorized signatory as authorized in Appendix 2 of this RFP or person executing, delegating such Appendix 3 in favor of authorized signatory. It should be in corporate capacity, that is in bidder capacity. In case of consortium, JV in the lead member capacity is applicable. Now your lordships may kindly see why they have rejected. Page 242. We had made a representation, they say, yes. Your lordships may kindly see East Coast Railway. Sir, with reference to the above subject, as per 2.14.1.1 of the RFP, DSC should be in the name of the authorized signatory as authorized in Appendix 2 or person executing, delegating such Appendix 3 in favor of authorized signatory. But in the instant case, the bid documents digitally signed by Shri Rahul Didwania, who is neither the authorized signatory nor the bid nor executed, delegated such Appendix 3 in favor of the authorized signatory for instant bid. In the instant bid, Sri Saurabh Ghosh is the authorized signatory and Rishu Agarwal is the person who has executed, delegated such Appendix 3 in favor of authorized signatory. Rishu Agarwal has delegated it on behalf of the company. He is a director of the company. He has been authorized by the company, by the board of directors. Two persons have been authorized. One is this Mr. Didwania and one is Rishu Agarwal. So where is the defect in the entire proceeding, my lords? They are misunderstanding the concept of person. This is a juristic person who has applied for the, my lords, in the bid. He is the bidder in its corporate capacity, Shanti Engineering. So they can be, Shanti Engineering has actually given the power to Mr. Ghosh.
Understand by board resolution, and then board resolution also authorizes one of the director or two directors jointly or severally to sign.
Exactly.
This is what you're.
This is my sum and substance of mine.
Let us see.
What's for 2 days, 3 days, I recent the two these papers are not in order. Some managers are submitted already. Just I have gone through it. Number one. Number 2 point is that number two, I will search for instruction or should keep it to next week any day. Substance
financial
bid is open. Technical bid is open. They have must have made a party to private party months. They must have the agreement.
Work order has not been issued. If work order is not been issued, my lords, I don't.
That's why I'm keeping. Let's may keep it to next Wednesday.
Of the contract.
There is a bridge construction. Bridge construction. Railway is
construction of railway
work for new railway. So it is a. So that's why I'm keeping. Let's may keep it to 11, 12, 13 any day. I will talk within 2-3 days. I'll take instruction.
Techno commercial
Why you wanted the elimination? If it is a competitive price, then where is the difficulty?
No, my lord. Because of
Price is competitive.
yes, there's a lot of people are there. It is not that he is alone. He was serial number one. Let's make come to the page 130, 230. Is 230. There is a 23 bidders, including the PSO undertaking. That is real Vikas Nigam is there, and that was acceptance of the document.
Railway Vikas Nigam is also rejected.
It's a bid, open bid now. This is.
No, I'm asking.
Who is that?
Not at the technical bid stage.
No, before techno evaluation on the month of March, these documents are received on 25th, and there is a list was published on page 230.
The difficulty is that what he has argued actually is a civil law.
Here is the issue. What I understand, my lord.
Under the Companies Act, it is the board of the directors who are in the helm of affairs of the companies. Now, the board of directors, if they have taken a decision or a resolution has been taken that we authorize such and such person, it is an authorization by the company itself, because the entire decision of the company is taken by the board of directors. So in that event, if they have also authorized one person to execute it or to sign it or to authorize it to engage or authorize an authorized person to do something on their behalf, there is a law which prevents. If the Companies Act does not really debar, then how can you as an authority debar?
Function is the company is one part, the function of the authority is another part. We
don't know. You are really going into the domain of the company that he was not authorized. It's a board of directors who has authorized. Who are you to say that he's not authorized?
That's why I think
that is what I'm saying. He does not know the nuances of the Companies Act, how the company functions.
Let's we keep it 12. 12th or 13, any day, let's keep it. I'll come with a proper instruction.
You have a law department, I believe.
Oh, we have a law.
Then why don't you take the aid of other assistants of the law?
That's why after receiving the copy, immediately I'll send to them.
No, I can understand that there is a signature which is missing because their signature is mandatory.
But they are going
not require
technically
it's a
proper
meeting of the eyes. Justice sees and then find that it is not there. But once the interpretation of a particular document comes, you do not take lead of your legal department. Then what is the law on the subject? And you have included the consortium, you have included a joint venture company who can come forward.
Later, when I'm saying, even though the legal department, without
just one.
But the private opposite party encroach the public road, village road, for which matter they have made a representation before the authority, that is the sub collector Anand 15 on 12 of 2025. But till today, matter no action taken after instruction. The village road is very narrow now.
This similar to PIL says there is encroachment on 2 plots. Similar to given the instruction.
Which plot?
Government plot. So we have taken action. That is my instruction. So far as 1 plot is concerned, we have already set the process in motion. Form, everything has been. Eviction, the eviction process has already been started. So far as 1 plot is
encroacher.
Encroacher private opposite party number 4.
He is a contractor engaged by you.
No, he is coming that I failed to discharge the essential civic amenities. This is what is your case number?
My case number is 6103, madam.
You have raised an issue regarding the providing the essential civil amenities. This the different case. You are not the right to a basic infrastructure, livelihood, dignity, everything you have played.
No,
Is it your case?
Only your lordship, I have given your lordship kindly see paragraph 4. I have stated that the plot number meant for village road.
But there is already a civil suit pending, so they can't take it. Another plot they cannot take it.
No, madam. Two plots, lordship kindly see page 15. That is though ODI, but it is reflected 3101. 15, madam. Your lordship, 15, madam. Your lordship kindly see 3101. That is reflected Rasta road and the grammar, my lord. And thereafter 3145. Two plot, my lord. Both are, my lord, meant for village road.
No.
Again.
The one there is matter, right?
The petitioner has quite the
Government has already formed monitoring committee and
There is a pressure.
so to
It is. It is very pressure language. It's so much. This woman.
the register has initiated on direction to Supreme Court.
Direction of the Supreme Court, then go to the.
130 is the direction in the bill. There are lots of committee. Page number is written below the. To facilitate effective implementation at the executive level, every state and union territory shall constitute monitoring committee for the management of the OCIS to be headed by the executive chairman, state legal service authority. A compliance and monitoring, that is at page 129, and then relevant, what's in it? F surplus 2, common 4.
Person want to do it. Further direction has to be done.
Committee has to say that.
That is what we say, that immediately the committee has to, which you have constituted, should be made functional.
It should function.
You will provide all the infrastructures, the facilities, everything to the.
That is, sit and decide.
The chairman will be the executive chairman of the legal services authority.
Home Secretary will be member.
The secretary of the government home department.
Member.
And the DG of the prisons or these. These are the 3 members. We are constituted now, we'll have to say that.
Just today I received that instruction.
Yes.
Item 17.
Okay.
17.
I look like kindly come to the. I've also submitted on video clip, man. Let's see there.
What video clip?
The entire picture in the video clip.
Or
the assault by the police person and the paramilitary.
What you were doing? Was it a peaceful protest or something else?
It's around 12 o'clock in the midnight, man. We're sleeping. It's continued till 5 o'clock.
What is this? The instruction. Is this serious thing?
No, my lord. The police they are protesting since 2023, my lord. Now they are constructing a road without any public hearing, violating the constitutional provisions.
No.
Now they are protesting that. Now they have come at midnight 12 o'clock. They have assaulted my lord.
Completely baseless. If your lordship may kindly see, this is the instruction furnished by the SP.
Several police personnel have been injured.
My lord, they are assaulting in the midnight children's, women's.
That is why your case is when how they sustain an injury.
Both sustain injury, my lords. But
in fact, they have gone to the spot.
The midnight, my lord.
They have entered the village to apprehend one Subhash Singh Majhi, to execute the warrant of arrest. He
More than 100
is wanted in
police personnel.
he was wanted in 14 number of criminal cases, and the magistrate that arrest warrant also we have enclosed. Now to apprehend that person because he has been escaping from law, but for several occasions.
Warranty.
So to execute that warrant, the police personnel with full force and everything, they entered the village, and he was having a meeting with 100 of villagers. So that is the cause when they wanted to apprehend him with two teams. There the exchange of and the police personnel to escape from the crowd because they were mercilessly beaten, stones were pelted at them. To stop all those things, when they that tear gas and everything
They came prepared,
and they escaped from that.
They came prepared
place.
before.
And the police personnel, they escaped from that place, and that particular warranty could not be arrested. And if your lordship may kindly see the photographs that we have given, several police persons were injured in that incident.
Any severe injuries are still? Oh, even if police, when a female police personnel are.
Yes.
That is kindly see annexed
And the medical reports also we have.
It's a false case. I'm talking. Mallards at midnight, 12 o'clock, they came prepared with lathi charge, tear gas, and only to apprehend one warranty. And they have assaulted women and children. Houses are broken down. Kindly see the video. Everything is clear.
No. Did you went to the hospital or the near primary center?
Several have taken a plea that because of fear, they are not coming out of their houses also. They are not going to the hospitals. I have taken that plea also.
Everything we have enclosed.
Has he surrendered? Warranty has surrendered?
I don't know. That's a false narration. No. They are in a better position to say. My case is that we are assaulted. From 12 o'clock to midnight to morning 5 o'clock. Only to apprehend one arrestee.
Is he a resident of that village?
The warranty is a resident of that village.
Mr.
Yes.
One 30 persons have sustained.
150 villagers were there. Page 5, if you lordship may kindly see.
20, 3, 8 persons. What are the allegations against that warranty?
Next year, kindly see page 37. The arrest warrant is there.
Which place is this?
This is Sijumali.
Where?
Sijumali, that is in the district of Korapu.
Well, they may be asked the village name.
Raigada.
They have entered into
Sorry,
village.
I'm extremely.
Raigada is a district. They have entered
I
into
just
village.
wanted a place, sir. I am not aware of the geographical things of the state that much. Now I have come to know that.
They are referring as
main districts.
They are referring as Sijimali Hills area. They may be asked a particular village where they have entered in that night.
I had been to those areas.
$37, no?
Well, page 37.
Well, kindly see the video. Very clear, everything is clear.
Who captured the video?
It was provided by the petitioner, the villages. And it is also in the internet.
Internet?
Website. different websites. In I filed one I also.
Law has to be taken course of what can be done.
My lord, I am here.
You can't in the garb of a public interest litigation see that every arrest and every case has to be dropped immediately, the bail is to be granted.
No, my prayer is not that.
That cannot be done.
But kindly see my prayer. My prayer is very clear, my lords. Since 2023, they have been on agitating on different issues that they don't have free consent. I mean, they don't have public hearing and they have not taken the consent. And this is going on since 2023. Now, right now, they are constructing a road. Now, no public hearing. Now, my prayer is to issue appropriate writs orders directing a judicial probe by sitting retired judge of the Honorable High Court or in the alternative constituted investigating SIT monitored by this Honorable Court for the investigation of the brutal attack of the police on the tribal villages on the midnight of 6th of April 2026 and also investigate the past incident related to the protest in 2023. Because since 2023, there are several persons arrested. And if a lordship will remember, this High Court, in that Supreme Court decided that bail matters, several, what can I say? I mean, several conditions were imposed to clean those police stations. These are the persons, man. And it's a fact.
They are trying to.
And it's not a new thing, my lord. Even that OMC is clear.
In the garb of, my lord, construction of road with respect to giving passage to the for bauxite mining to Vedant Alumina, they are mixing these issues. If your lordship may kindly see, please kindly. Your lordship may kindly see para 6. Regarding that also the superintendent of police, what the superintendent of police has said. But he may kindly see.
Keep a quiet. Let us go through it. Keep it tomorrow, then we'll see that what can be done. We are just looking just for. And the videograph is already there.
Yes, my lord.
Where the committee?
I'm submitted to the
pendrive.
I'm submitted to the
Pendrive. Give it in the pendrive. Okay.
Well, I read this item number 19. Item 19 will be for the
pendrive.
item 19.
next week.
Next week. Yes, sir.